And we are recording, right?
We are recording.
And
Thank
we're on
you.
YouTube.
Almost. Stand by.
Do you want me to do the announcement or do you just want to jump right in, Terry?
I think you should do the
You
announcement.
can do your thing as soon as we're up on YouTube. You there, Dan?
Terry, you're on YouTube.
All right, Mike, you can start. You want me to call the meeting to order?
No, well, yeah, go ahead.
All right. This is a special meeting in Narragansett Planning Board, Wednesday, July 29th, 2020. Let me take roll first, Mike. Mr. Layton,
Yeah.
Dr. O'Neill,
Here.
Ms. Blasiak,
Here,
Mr. Fleming, I'm here. Mr. Indalia is not here as of yet, but he'll probably be here. So, Mr. DeLuca, you want to make your regular announcements here?
Sure, it's just a little technical announcement for people who don't Zoom as much as we've been doing in the last 3 or 4 months. My name is Mike DeLuca. I'm the planning director for Narragansett. Welcome to this special meeting. This is a follow-up from the July 9th meeting at which we had one item to review, and that is the 3-student regulation. Before we start, I want to provide a brief tutorial on the use of the Zoom platform. This is Zoom webinar. So Zoom meeting usually has everybody's picture up who's in attendance. Right now we have 11 panelists, half of whom have their cameras on, and we have 42 attendees. But the attendees cannot be seen on the screen. If at any time when the chairman opens the floor for discussion, the thing to do is to raise your hand. You may raise your hand by first clicking open the participants box, which is in the bottom center of the screen. The participants box lights up on the right-hand side of your screen, and at the bottom of that is a little icon that says raise hand. When you click on that, a little hand pops up on our screen, and we can see that you want to be acknowledged. If you are on a phone call, which we have I believe we have 3 call-ins right now, 3 people on phones, you may use punch star 9 to raise your hand. And that little raise hand icon will show up. Star 6 will unmute, and then star 6 again will mute your microphone. But you have to be acknowledged by the chairman. We follow Robert's Rules of Order. The chairman runs the meeting. He identifies who's speaking at any one time, and no one is allowed to speak over anyone else. We'll try to get through all of the discussion. As you know, we had several people waiting to speak at the July 9th meeting when we ran out of time, and the chairman is looking to bring those folks in. I took their names down at the end of the meeting, and we're looking to get commentary from those folks. It's up to the chairman as to whether or not he wants any further testimony beyond that. And reminder to all the board members, when we get to the point of votes, we'll do roll call vote. Heidi Patron from my staff is here and she can handle the roll call. Back to you, Mr. Chairman.
Okay, well, let's do the consent agenda first. The approval minutes for July 9th and July 21. Does anyone have any commentary on either of those?
I do not. I have no changes or edits.
Yeah, I didn't have any changes on those either, Dr. O'Neill.
Nor I.
Okay, so I have a motion to move the consent agenda, please.
So moved.
Motion by Dr. O'Neill. Do I have a second?
I'll second that.
Seconded by Mr. Layton. So I'll take a roll call vote. Mr. Layton,
Aye.
Ms. Blasiak,
Aye.
Dr. O'Neill,
Aye.
Mr. Fleming, aye. Passes 4-0. The next is the regular agenda, the recommendation of Town Council zoning text amendment, section 2.2 and section 7. This is a continuation of the last meeting, just so we make it abundantly clear, which we made it last meeting abundantly clear. We had taken 2.5 hours of oral testimony. And again, our obligation is to make these meetings available to people and to get a cross-section of opinion. The board felt that was sufficient time. We actually wanted to end it there, but we ended up committing to, as Mr. DeLuca alluded to, these 18 people that had been waiting for some time. That's going to be the end of the public commentary. Whoever Mr. DeLuca wrote their names down, we're going to try to get those people. If not, that'll be the end of the public commentary. As we said at the last meeting, numerous times, which was July 9th, people had an opportunity to write to the board. We received over 100 pieces of communication, written communication. I've never seen any response like this. Just so everyone knows, we received things on all sides of the issue. People for, people against. Again, we took 2.5 hours of public testimony. We're going to probably take another half hour, 45 minutes with those 18 people today. That will be the end of the public commentary. And then the board will deliberate, talk to staff, talk to legal, talk among themselves, and we'll make a recommendation. So the public understands again, so I say it repeatedly, this is an advisory opinion to the council. Once we send this recommendation to the town council, this whole process is going to start all over. I'm going to ask Mr. DeLuca to, with our recommendation, to forward all the correspondence that we received to the town council. He's organized it all in files. I'm going to ask that accompany our recommendation and the staff summary to the council, but the public has an opportunity to talk in front of the council, however the council decides to hold that public hearing. And they also have an opportunity to write to the council. So I'm completely comfortable that we've given every opportunity for people to voice their opinion and that the board has a good cross-section of opinion by which to make a recommendation. So, and just so you know, folks, the council has set down August 17th to start their hearing. They expect a recommendation from us. I see no reason why we can't give a recommendation tonight unless the board feels otherwise, and I'll always listen to the board. But I would hope that the board would give us a recommendation tonight, and we're going to go forward. So right now, we're going to try to identify those people. Again, I wanted to shut it down last week because I thought we had enough, and I think the board thought we had enough, but we did commit to these 18. They will have 3 minutes each, and Mr. DeLuca is going to try to identify those people.
Mr. Chairman, I've been up and down the list and I do not see any names that correlate with the 18. So let me just read them out if that's acceptable.
Sure.
Here's what I had. The first one was just someone named Andy with no last name or initial. The second was Jessica Dominy, D-O-M-I-N-Y. Third was Davia with no last name. Fourth was Ryan Menard.
All right, let's stop there. Any of those people identify themselves?
If you're here, any of those first four, please raise your hand. I don't see any additional.
Okay.
Moving on to 5 through 8. B. Gendron, Emma Crisfield, Rebecca O'Toole, Martin Schulman.
No one there?
Scanning.
Martin.
Is here.
Okay,
Let me bring Martin forward.
so when he comes forward, you can identify yourself. You have 3 minutes to state your position, sir.
And you need to unmute, Mr. Schulman.
Thank you. Thank you, Mr. DeLuca. Thank you, Mr. Chairman and members of the board. I appreciate you giving me a moment. I won't take more than 1 moment just to ask that if you could confirm that you received my email to the board, that would be sufficient for me to speak my piece. And I appreciate all the efforts you're doing. I thank you very much for your patience. I know it's trying. If you could just confirm that some way, either by email or verbally today, I'd be happy to shut up.
There were over 100 pieces. I tried to pay attention. I believe we received yours, but I can't say for certain. Mr. DeLuca would have to confirm that upon looking at the emails after the fact.
Okay.
right now, I can't confirm. Mr. Schulman, your name looks very familiar. I want to say yes, but I've got a pile of 175
Yeah,
documents.
I want
I
to say
can't
yes.
go through it
I want to
all.
say yes too. And
Understood.
any of the board members recognize Mr. Schulman's letter? I mean,
I recognize the name, yeah.
you do?
All right, well.
Okay,
Thank you very much, and I wish you all the best of health. Thank you.
appreciate it. Thanks for your
Thank you.
time. Okay, who
Right.
else you got? Who else is on the list, Mike?
All right, moving on from 9 through 12. Jessica Del Torrio, someone named Allie with no last name, Allie. Donna Botari, Robert Cahill Sr. I don't see any of them. Hold on. Not seeing any of them.
All right, who's the next four?
Joe Alves, Steve, P. Masters, Nicholas Barnes.
Do we have any of those?
Waiting to see if they'll hit their raise hand. Giving a moment. None of them have raised their
All
hand.
right.
Two more.
I believe Mr. Alves sent a letter, so go ahead.
Two more. Sydney Story and Amelia Bartoloni.
I think Mr. Story sent a letter.
Going once, going twice. I do not
Nope.
see either.
Okay.
That leaves
Thank you.
us with, there are two other attendees with their hands raised, Mr. Chairman. It's your call.
No, I don't know how many times I have to say it.
Yep.
No,
Okay,
unless the board wants to continue with more discussion. And I'll ask Ms. Plasiak, do you think we have enough?
I think we have enough.
Thank you. Mr. Layton,
We do have enough, thank you.
Dr. O'Neill. Doctor,
I see his computer on, but I don't see his phone on
you
anymore.
muted, Joe?
No.
No? Dr. O'Neill, unmute.
all right.
I'm concerned we lost the doc.
Yes, I think we did.
Okay, hold on.
Hello,
Oh,
I
here
hello,
he is.
lost
Michael.
For a moment, sorry.
Joe,
Yep.
are you there?
Am I back? Am I back?
Yeah.
Okay.
Joe, do you see any
Yeah,
need?
yeah, I think we've had a lot of discussion and a lot of cross-section, wonderful list of letters and comments from all those folks who wrote letters. I think you said 170 some. And I don't see why we need more. I mean, we know
Well, we
the
don't-
gist
we-
of the whole thing.
We don't have a legal obligation from our solicitors except to provide some opportunity, hopefully for some public commentary, which we did more
Well-
than the other issue we've had. And people have been able to write and they can send their thoughts to the council after this, so.
Right. Or,
think-
you know, did these two people already write letters? So many people have asked to speak
Yeah, I
who
mean,
have also
some
written
people,
letters. you know?
some people that still want to talk, Joe, have already spoken in the first meeting. And as you know, we generally try to keep people to one comment.
No, yeah, that's more than adequate.
And they've also written commentary through emails or letters. So
Yeah,
I think
no, that's more than
it'd be
sufficient.
foolish
Yeah.
to say that they haven't had a sufficient time to express their. view.
Yep.
I think that's kind of where we are at this point. So what I want to do is get again to the discussion by the board. And then ultimately, hopefully to a recommendation, and hopefully Mr. Indalia will be in soon.
Checking.
But we, again, this is the portion where we speak we talk among ourselves. We ask our solicitor for any questions we might have and the staff. Ultimately, we're going to make a recommendation on this ordinance that was presented to us. And as Mr. Marcella said to us last meeting, we could either approve this as it's submitted, back to the council. We could reject it as it's submitted, and under either of those scenarios, I would want the motioner to, and the majority of the board voting that way to give reasons why we support it or why we oppose it. Or we could approve it with modifications. And, there are a number of components of this ordinance that are subject to discussion and modification, and, that's up to the board. We also need to make a recommendation, I would think a separate motion relative to the items raised in Mr. DeLuca's staff summary, specifically how this proposed ordinance comports or is consistent with the comprehensive plan, and how it's consistent with the, what do we call it, Mike? The criteria for zoning,
Purposes of zoning, yes.
purposes of zoning. So, and Michael discussed those in his staff summary, and I know that you've all received that and read that. Again, I mean, I'll speak for myself on one point. We received so much commentary between the oral testimony last time and all this written testimony. It was fabulous, I thought. I mean, people, and Joe, you've been on board longer than I, but in over my 20 years, I've never seen any kind of response like this in terms of public commentary. So that
Yeah,
to me,
no, that's true. Yeah, that's true.
It was encouraging. And again, I don't count heads. People say, well, it's 27 on one side, 18 on the other, so they must prevail. I think that's foolish. We don't, and I can't speak for you guys, but I don't count heads. I look at the arguments that people make, and the rationale that they give. I think it's
Yeah.
fair to say, if anybody thinks that appropriate commentary wasn't made available or input wasn't made available, we have significant commentary, both oral and written, on both sides or all sides of this issue. This was not in any way dominated by one side, in my view. Again, I'm not counting heads. I don't think that's a proper.
Oh.
I think we lost Terry there.
Mm-hmm.
Uh-oh. Terry, you froze, if you can hear us.
It's too warm a night to freeze.
Right. Good point. All right, he's dropped out. He's going to come back in a minute.
Michael,
Yes.
I am looking for the email that has the staff summary on it.
Yes, I attached it to, I think, the one I sent you on Monday morning.
Okay. Because I just have so many emails from you now that it's like getting a little muddy in my email box, but
Yeah, because I updated it. It's now dated July 27th.
got it. Yeah, I think, okay.
I'm waiting to see Terry's calling. Jill, do you see him? Do you see Terry?
No.
Yeah, just promoted
Oh.
it.
Oh,
Oh, you see him? Okay, I don't see him.
Okay, I didn't catch him.
I was
There he is.
on mute.
So sorry, folks. I don't know what's going on with my internet, but I apologize. I get back as quickly as I can. I have to reset it and then get back. So are you there, Mike?
We are here.
Okay.
Yep, we're all here.
All right. So I don't know where I got cut off in my rant. But I would ask again, Mr. DeLuca, when we get to this, to when you prepare this motion, and this motion is going to be specific to what was presented to us, but there's going to be a lot of discussion about the whole issue of, student rentals, seasonal rentals, and the whole method of trying to get a handle on this and addressing this. So I would hope that the staff summary records the board members' talking points and discussion. It goes on to the council. So if the council's not watching this, they can understand all the discussion that we had. And also that we can include all the correspondence that was written. We can do that. Is that okay, Mike?
Yes, sir.
Okay, so I think we're gonna have a discussion here, and if Mr. Berg could come on, I think he said when we need him, he'll open up his camera. There he is, and your mic there, Mr. Berg?
Oops.
Yes.
Yeah.
Okay. So, Mr. Berg, and again, board members jump in, please, at any point in time. At one point, you had indicated, and maybe it was obvious to everyone but me, but I asked the question, and maybe the board, it's not obvious to the board, but this ordinance as presented by the council, this 3-student, if it were enacted, it would run concurrently with the existing ordinance of the 4 unrelated that's currently on the books. Is that correct?
That's correct.
It
They're
would-
not mutually exclusive. They both can be enforced.
And it would not supplant that. That's not part of the motion for it to replace that in any way.
No, this is standalone proposition.
Okay. So then the second point, which is what you had answered to the council and you answered to us last time, in your opinion, the 4 unrelated is based on the Supreme Court decision. You feel it's enforceable at this point?
It's enforceable, and the constitutional arguments that were made before that were successful in Superior Court in the early 90s and municipal court more recently would not prove fatal in trying to enforce it. There are other defenses that would be available, but overall, yes, I do believe it's enforceable.
So I guess I don't totally understand that, but what would it take the town if they wanted tomorrow to start to enforce it? Would they just in fact do that? Or would they have to get some kind of legal blessing to do that?
No, well, it takes some coordination between some of the departments, and but it could be enforced if the resources were devoted.
But it's not, you don't have to return, forgive me if these questions are stupid, but we don't have to return to Superior Court to get any kind of blessing on it.
No,
Or the Supreme Court.
no. If the town has the will to immediately begin enforcing the 4 unrelated and wants to devote the resources, we could start doing so. I would point out that most violations having to do with building codes and zoning ordinances come from citizen complaints. So that's the usual genesis of violations and investigations. But there's no obstacle or impediment to receiving a complaint, investigating it, and if it's appropriate, lodging a violation in municipal court.
And that would be the method at this point to enforce the 3-student if it got enacted by the council, generally speaking.
Correct.
There's really no infrastructure set up to do inspections of any kind. It's all driven off complaints.
Complaints, and perhaps we could even refer to the rental registrations. How many bedrooms, how many tenants are in pieces. There are some. If we want to be more proactive, I do have some ideas on how we can be more proactive.
But if the 4 unrelated is enforceable, if it is, if that can be put in and at some point in the near future begin to be enforced, that for the most part encompasses the situation with students living in a house, does it not? Unless there are students that are brother and sister or brother and brother or sister and sister, if they're related. But generally speaking, students in a house are unrelated. And if
It
the
would
4
apply to anybody, including students. If there's
What's
4
that?
unrelated students in a house, then it would apply.
it would apply. Okay. Because I look at things, and I did, so they both run together. You think that the 4 unrelated is enforceable at this point. And I'd also refer to Mr. DeLuca, but Mr. Byrd, maybe Mr. Marcella, because he has some knowledge too. There are a number of towns, I think over 30, that have a limitation on unrelated people that can live together.
Yes. If you're looking for me, I'm sorry. I had done some research on it back a while back. And I believe, well, I don't have my the file in front of me. I believe it was 35 out of the 39 cities and towns did in effect place a maximum number of unrelated people who could live in one home together as a household. And the range went from 3 to 6. Some communities had as many as 6.
It couldn't be
Most
less
had
than
3 or 4.
It can't be less than 3, according to state law.
Under the state zoning law, thank you, it says that you may have, the towns can designate how many unrelated people can live together, but the number shall not be any less than 3.
But, and there, to your knowledge, those are, for the most part, being enforced by those respective towns.
For the most part, I believe they're all being enforced and actively complied with. Ours is the only one that I'm aware of that was found to be invalid by the Superior Court of the State of Rhode Island.
Because Judge Fortunato, right, am I right, Mr. Berg, at some point deemed it unconstitutional,
He deemed the Narragansett ordinance unconstitutional.
specifically the Narragansett. And then we put in the 4 unrelated 4 years ago, and the municipal court judge affirmed essentially what Judge Fortunato had said.
That's correct. He, I believe correctly concluded that he was bound by Judge Fortunato's decision.
He was bound by that. But now you think, again, not to beat it, but now you think, given the Supreme Court's decision in the Providence case, maybe the shackles are off on the 4 unrelated.
That's correct. A higher court than the Superior Court has essentially overturned Judge Fortunato and deemed a very, on a similar issue, if not the same issue, ordinance to be constitutional. So again, the constitutional arguments that Judge Fortunato based his decision on when addressing our ordinance have been overruled by a higher court.
Okay, that answers my, because as a layman, I'd say, well, how does 3 students, or how does an ordinance specific to students relate to another one that's related to unrelated, and it's in a different municipality? So
That's true. But in the Supreme Court case that just came out dealing with Providence's ordinance, they had language in their decision that strongly suggests that it's not just limited to students, that towns can make distinctions. And they specifically discussed Judge Fortunato's decision and said he was wrong, and cited the United States Supreme Court case as precedent that Judge Fortunato probably should have followed back in 1993. So based on the language that the Rhode Island Supreme Court used in the Providence case, I'm confident that the constitutional issues that were fatal before the Narragansett's ordinance would not apply.
okay. Thank you. Mr. Indalia has joined us. Mr.
Yes.
Indalia, how are you?
I'm here, Your Honor.
Thank you. Thank you. So we were just talking to Mr. Berg about the, as you could hear, the 4 unrelated and the 3 student. And these, if the 3 student was enacted, it would run concurrently with the 4 unrelated, would not replace that ordinance.
Understood.
Which gives me some concern, not concern so much as just head scratching about how some of these things would be administered, and it seemed to me a lot of redundancy between the 3 student and the 4 unrelated, notwithstanding the 3 or 4, but as we've said, the 3 students or 4 students are going to be by and large unrelated. So that ordinance is going to take care of, I guess, the 5, 6, 7, 8 tenant houses probably could be stopped with the 4 unrelated, Mr. Berg, by just enforcing that.
It's always good to have more than one arrow in your quiver when dealing with these types of issues. And I believe there are some instances where the college student ordinance might be easier to enforce than the 4 unrelated ones.
Interesting. I've been thinking of scenarios where I would think the 4 unrelated would be easier to enforce. I mean, because I think most people, I think, and I may be naive, are going to try to comply with whatever laws are on the books, but there's always people that are going to try to find a way around things.
I don't go to college.
What's that?
I don't go to college.
What do you mean?
Well, when the guy
Oh.
shows up to try to enforce it, he says, I don't go to college.
Right. And I think, I mean, listen, there are some things that
You
aren't
didn't get in
even,
college being stupid.
there are situations where you're not even trying to circumvent anything, where you're gonna be able to put 4 people in a house. It's a common occurrence. It was a common occurrence when I was in school, and I believe it is now, that sometimes you have 3 students or 2 students in a house, say 3, and you have some non-students renting in the same house. I rented in Narragansett for 3 years, and in 2 of those years, I had roommates that were no longer students. They had graduated, but they wanted to continue to live in Narragansett. They were working. So I think you could still have 4 people with the same demographic characteristics, if you will, as students, someone right out of college. Now, if it went to 5 or 6 or 7, the 4 unrelated would stop that for the most part, unless 2 of the people were related. But it seems to me there are more loopholes in the 3 student. I could be wrong. I don't know how the rest of you
Let me say this.
know about that.
There's enforcement. Both these ordinances present challenges in enforcement. And the reason I said that the 3 student one might be easier to enforce is because there are publicly available databases that list students at URI that can be compared to leases that are filed as part of the rental registration ordinances and other ordinances that require that these be publicly available or made available if the building inspector shows up. So again, both of these are going to present enforcement issues, but it's better if the town has multiple options of enforcement when there are complaints, or if we want to be proactive. I think the student one actually might give us some options that the 4 unrelated wouldn't, as far as enforcement and proving our case.
Yeah, the presumption there is that everybody's a URI student, and that isn't going to always be the case. If it's a student ordinance, it's not directed at URI students. I mean, there are students at Salve, at Rick, at PC, at Brown, and in the pandemic age, there's going to be more and more people that are, doing all their schoolwork from home. So, you're going to have to check multiple colleges to identify the students. I think it's not just URI, right?
No, any college.
Right.
But this wouldn't apply to a situation where a student is living with his parents. That's owner occupied, specifically excluded.
Right. So that was another
What if
thing.
what if they were renters?
Yeah. If the family rented year round, let's say they had 4 college students. I know that's unusual. It is unusual, but I had 3 in
They wouldn't
college.
be unrelated. They wouldn't be unrelated, but
It doesn't matter. The 3 student doesn't talk about relation, right? It's just students. So someone,
In non-owner occupied homes.
right, someone that rented a house year round that had 4 children all in college would be in violation, correct? Because they don't own the home.
Hypothetically, I mean, they
Well,
could-
no, not hypo. I mean, they have 4 students in the house and they don't own it, so they're in violation, it would seem to me. I don't know how hypothetical that is. It is? No, I mean, they're in violation, right?
Arguably.
Okay, here we go, lawyers. Here we go, lawyers. I don't know. It seems pretty straightforward. And now I had another question. What about a house in a trust?
What?
A house that's in a trust,
Oh, trust.
not owned by the people, it's owned by the trust, correct?
Look, we could throw out a million hypotheticals.
That's the point.
As I said before, enforcement of these ordinances is going to present challenges.
Right.
And like with any ordinance or any criminal statute or any law, it's up to the enforcing authority to make decisions on who to prosecute and who not to prosecute, and whether they can carry the burden of proof or not carry the burden of proof.
Correct.
So if a situation comes up, we're going to look at it. We're going to decide whether we can carry the charge. We'll investigate. If we can't, then either we won't charge, or if there's a pending charge, we'll dismiss the charge. Again, no law is perfect. No law is going to cover every scenario. But the Supreme Court, the Rhode Island Supreme Court, in the Providence decision, said that an ordinance does not have to be perfect. It does not have to address all the evils that it was intended to address. Or it doesn't even have to be perfect in addressing the evils it's intended to address.
I totally agree with everything you said, and that was my point for raising those things. I think, to me, the 3 student provides more opportunity for those, I don't call them hypotheticals, I just call them one-offs that are difficult to adjudicate and administer than the 4 unrelated, but that's just one person's opinion. But I totally agree. Nothing's perfect, and there's always ways around it. I just happen to think as I think about this for the last month or so, I just come up with more scenarios where the student provides some difficulties, but that's me.
Well, I'll say this. I'm here to comment on legal issues, legality, and enforcement. Ultimately, this is a policy decision. It's up to the town council to decide from a policy standpoint, from a priority standpoint, whether they want to adopt this ordinance as written, they want to make it 4 students, 5 students, or 2 students, whatever. My purpose here tonight is just to fill you in on questions regarding the legality and the enforcement of this proposed ordinance. I can't really comment on the policy aspects.
Got it. I understand. And again, you've made some suggested changes to this, such as the owner occupied, or that was actually part of the Providence one, right?
Correct. I think if you take that out, that might create some constitutional issues because people have rights when it concerns their own home that they might not otherwise.
Correct. I get that. Okay. So we don't know. I mean, there are a number of scenarios where you would have to scratch your head and say, how do we adjudicate that? I'm not sure who that falls to, municipal court, or there's some appeals board or something. I mean, there must be some infrastructure to do that.
Well, the decision to charge is made by will be made by the building department. And then once it's charged, whether to proceed with a prosecution or whether the town can carry its burden of proof will fall on the solicitor's shoulders.
Right. Okay.
And
Okay.
if we can't prove the case, we'll dismiss it. Or we'll take it to trial and see what happens.
Fair enough. Fair enough. And so in this ordinance, you had made 3 changes. Refresh those again for us from the Providence one. One was all zones rather than specific dwelling zones.
Correct.
And the
The other
second
was to make it 3 students per unit as opposed to a single standing home. In other words, it would apply to multifamilies with each unit limited to 3 students.
the Providence only applied to single family homes and certain zones.
Correct.
And then there was a third one that you had, the student definition of student, you suggested taking out the commuter status.
Correct. And my reason there was from an enforcement standpoint, it's difficult to prove when a student, they can be enrolled and not be community campus. I don't think it affects the legality of it. It just creates an obstacle to enforcement.
And I'm assuming that a student is a student of any type, part-time, full-time, graduate, undergraduate, whatever. It's a student.
Correct.
Okay.
I have a question.
Yeah, go ahead, Ben.
On that issue, and Mr. Berg just brought up in terms of the definition of the student and the enforcement. Who is a defendant or respondent in a prosecution under this statute? The homeowner or the occupant?
The homeowner. That would be my opinion.
And does it apply to known occupants or just any occupants? So I lease to Eric, Don, and Vinny, but there are 3 more, or just yeah, Eric, Don, and Vinny, but they invite 3 more people in unbeknownst to the homeowner.
I presume that's
Is there a knowledge aspect to this? Is there a mens rea aspect to it, Andrew, or is it just simply a strict liability?
prohibition is that the dwelling unit shall not be occupied. So I guess it's going to boil down to the definition of occupied.
And are we
Any
defining
penal,
occupied?
go ahead.
Are we going to define occupied, or is it our opportunity to recommend that such a definition be given? Because occupied could be means crossing the threshold, or it could be meaning to stay there as a domiciliary or a residence, right?
I think what will happen is with most criminal statutes or penal type statutes is the court will apply a common sense definition. And then any benefit of the doubt, it's called the rule of lenity, will go towards the person who's being accused. So probably occupied will be given a narrow reading by the courts to mean the person actually lives at the household.
Okay,
I don't think a transient visitor is going to qualify.
okay. Thank
Then
you.
anything else at this point?
No, I just because it was something I was going to address later on, but since he brought up the definitions that he was making as to the college student and the commuter status and all those were close enough related, and he answered my questions as
Do you have
usual,
that?
the Berg to my satisfaction.
Do you have anything else you want to talk to the staff or Mr. Berg about? This is the portion where we're going to hash out all that before we get to some kind of recommendation. So.
Well, I assume that you and me and the rest of the board are going to have our typical back and forth to figure out what we're thinking as a whole, correct?
Yeah. This right now we're just trying to hit Mr. Berg whatever questions we have, or Michael or whoever, and then we're going to have our discussion. Yeah.
No, I think Michael's certainly given us plenty, and Andy was really helpful tonight.
I'll be monitoring. If you have any other questions, I'll be in the
All right. Let me see if anybody else. Dr. O'Neill, do you have anything for the solicitor?
Well, I guess it's not his bailiwick in terms of the imposition of the ordinance that's already been in place. So I don't think I can. No, I don't think I can ask him anything specifically. You've already asked him, is the 4 inhabitants enforceable? And he said yes, and I would repeat that. But
Yeah, in his opinion, it is. Okay, Robin, do you have anything?
I guess the only other question I have is sort of goes back to this definition issue in the sense that, what if the person, and it was raised in the staff report, what if the person has a full-time job and goes to college at the same time? Is that considered a student? Is there a certain number of, like, how picky are we getting about this definition? Because I don't know. Again, it's tricky. So
technically, if the person's enrolled, then they're considered a student, even if they also have a full-time job.
so even if they're only enrolled in, let's say, one class that's at night and they have a full-time job, they're considered a student.
Yes.
Okay.
Mr. Layton?
I'm all set with Mr. Berg. I do have a question for staff. So I don't know if we want to transition or continue.
Sure, you can ask that now, because then later on, we're going to all talk among ourselves to see how we all feel about this. So why don't you ask Mike whatever you need to ask?
Well, first of all, this goes back to the previous meeting where there was a spokesperson from URI who had described the relationship with the Narragansett Police as a working relationship, working towards reducing the complaints, reducing the nuisances. And I was very happy, Michael, that you followed up with the chief. I'm very happy that the chief is here. And I'm extremely happy with the 3-page letter that he put together confirming that the incidents have indeed gone down. What I'm wondering about, and it may be something that the chief has to address directly, if Michael, you don't know, but it is indeed this working relationship between URI and the Narragansett Police. And is that indeed an equal and fair relationship that's on the improving side, and actually with the communication that we were told about in the last meeting? The numbers prove it out, but I'd just love to hear from you, Michael. You've had discussions with the chief, and I'd certainly love to have the chief weigh in on this letter that I thought was very helpful.
I'm going to defer directly to Chief Corrigan because he's got the stats and certainly the personal experience that goes back several years with the university. And the way it has worked over the years is that the police department has been one of the primary conduits for communication between the town and the university, along with the town manager's office. So I'll pitch it out to Chief Corrigan.
Chief,
Good evening.
you on? There you go.
Yes, yeah, we do have an excellent relationship with URI. Specifically, I would say the Dean of Students, Dan Graney, since he took over the position in 2017, the relationship has improved a great deal. They provide various services. You know, the issues that student renters, there's quite a bit of it that really don't fall within the law enforcement domain. A lot of the disturbance that they create in neighborhoods are what we describe as being, you know, lawful but awful. You know, voices and slamming of the car doors and the carrying on that happens with the 18 to 22-year-old demographic that the 40+ crowd doesn't appreciate. So we work a lot with both the realtors, the landlords, and with URI to try and address some of those issues that fall outside of our authority. And so what URI has done for, they have their policy on off conduct. So every police report that's written where we identify a URI student gets sent to them, and they will follow up with that student on the basis of the fact pattern and what it was. You know, if it's a serious felony, they could be, you know, maybe expelled or suspended. If it's something like a possession of alcohol by a minor, they may just have to, you know, stay out of trouble and, you know, write an essay or something. But they also provide other services. They will do ride-alongs with police officers during the peak times and interact with the students, remind them that there is going to be consequences for bad behavior on campus, as well as what they deal with the police department. And also been working with us to try and set up activities on campus. So, like, as a way of giving you an example, traditionally we always have a problem the very first week that they move in. So what URI has been trying to do is have some kind of events on campus where a certain percentage of the population will stay on and be doing things there, and it kind of eases things up a little bit in the community. It doesn't make it perfect, but it does mitigate the problem.
Yeah, that's good.
This is your question.
Well, I appreciate putting that letter together and seeing the numbers. It was very important to me. It was interesting in reading a number of the letters that mentioned that you don't have to be a student to be loud and be a nuisance. And obviously, when you're in these situations where you're trying to break things up, that's probably one of the first questions you're trying to get to is, are these students or are these people that are just there for a vacation? You're probably having to sort that out right away when these things occur.
But the sorting out occurs after the fact. The community policing division will go through the reports and try and make a determination who it is and whether or not it's something to send to URI. We don't focus on what the group of people is. We focus on the behavior. That's where our enforcement comes in. So, you know, a lot of the community policing, if you will, happens, you know, before the problems in August when we're talking to the landlords and make sure that they're engaging with the students. And they've been responsive as well. I should I should have recognized that, asked for their cooperation when I became the chief, and they have stepped up and done a lot. And so has the neighborhood associations. You know, it's important to get the feedback from the people in the community as to what's the behavior that you're seeing, what are the problems, because as we do different things differently, the problem kind of evolves. And so we have a continual feedback loop on our action plan to adjust to that.
Excellent.
Terry, can I ask the chief something?
Yeah, absolutely. Joe, go ahead.
Yeah, Chief Corrigan, now talk to me about the summer. Obviously the students, and you described things very well. And by the way, thank you for that letter. That's very good. But talk to me about the summer. Don't people come in from Jersey and have a good time and raise trouble? Yeah, Terry and I are from Jersey. Bother the neighbors. Is this? And what about the students in the summer? There are graduate students and other student populations in the summer.
Right. So the nuisance ordinance the town has is in effect year round. The only difference is the amount of time that the sticker is going to be placed in the house. Traditionally, we don't have as much in the summer. That's been different this year. Our noise complaints are way up this year. But for the most part, it hasn't really been house parties. Just to remind you of the ordinance, it does speak about the size of the gathering and some other behavior. We've had a lot of complaints about fireworks, and we've had a lot of complaints about like the one night stays. People move in and they're only renting there for one day and they're going the next. So the turnover has been a complaint with some of the members of the public, but we still look to enforce the ordinance. It's depends on the officer. He's gets a complaint. The peaceful enjoyment of the community has been disturbed. Someone's complained, so the officer goes and he'll make his observations. He'll document it in a report, and then come Monday when community policing comes in, they're going to review that. And if it fits the nuisance ordinance, no matter what time of year it is or who the people are, a sticker is going to be applied. And if they were staying there just for one night, it doesn't matter that the sticker applies to the residents, not to the people.
Thank you.
Yeah.
Thank you, Chief. Anyone else have any questions for the chief or Mr. DeLuca? No? Thank you, Chief. Appreciate it.
You're welcome.
Okay, so again, we should probably talk each board member, as we always do when there's an important decision, folks. We don't just vote yes or no. We talk about how we feel and have a discussion. Again, I think our motion has to be, when someone crafts it, has to be specific to what's presented to us. But also, I'm going to make sure that some of the commentary of all the board, mine and everyone else's, gets documented under the discussion section of the summary of this meeting and gets forwarded on to the council, because I think it's important to talk about all the issues, even though the motion is very specific to the three students, whether we're going to approve it, reject it, or modify it. So anybody want to start? Joe, do you want to start? Or?
No, I'd be happy to start. So to start back, the number that is proposed here, there's always history here, and you already alluded to it. We went through, in 2016, we went through hearings, and we had input from student population and URI, and also from the various landlords and the different groups in town were represented. And at the end of that, we came up with that number 4. There was, discussion and not total disagreement. Obviously, 3, 4, 5 is probably the most popular numbers that were bandied about. And then we came up with 4, and not to quote too many of those specific letters, but there are a lot of people who I think, as you mentioned this earlier, Terry, that a lot of people abide by the law. And so they created 4-bedroom structures, houses, whatever, for rental on that basis and abide by it. So the idea of going to 3 because of a ruling up in Providence and and not applying the rule that's already there, because we, for whatever reason, enforcement wise has always been a problem, and that certainly should be addressed. Some of the letters suggested ways to address it. Hopefully those will get to the town council. There are ways to raise funds to have a person who would work with the building inspector in that department to enforce it and make sure people abide by it, and to actually go into these structures and make sure that they're not violating it. There's another aspect to that which I would like to pass along, and I think it's mentioned in when we're talking about the comp plan here, and this is the safety issue. As you know my background, the safety issue here. So if somebody takes a garage, the 6,000 square foot lot with a few bedrooms, they take a garage, 2-car garage, close the doors off, and create 2 bedrooms. What's the access? What's the exit for the people who are in there? In general, those windows are not the knockout type of windows. There's only one exit that I know of in most garages, and that's through the house, through the kitchen. And what about the attics? Most people have an attic if they convert to bedrooms, because people were talking about 6 and 8 bedrooms. Remember that? How the heck did that ever happen? In front of our board, unless you have 2 acres, how do you ever have 8 bedrooms? I mean, so back to safety though. You have that nice little stairway to the 3rd or 4th floor, and how do those people get out when there's a fire? And how about the basement? If people convert basements, a lot of basements have just those little short windows above ground, and a lot of people with basements, there's only one way out. So I think there's another issue here that I don't want to raise too big a red flag, but I think maybe it's time to look at this issue, and the number of people in the house isn't the only issue here. That should be looked at. We had more than a few people mention that they had these large numbers, like boarding houses, and they were upset about us coming up with a restricted number. But I've been on the board a long time, and as I say, if you come in with 2 acres and you want to put up a 6-bedroom house or whatever, 7-bedroom house, and you have enough parking area and you have good sewer and water and all that, that's your business. But in these areas that we're talking about, where people have these places, those are not 2-acre parcels. So there's something been going on here for a long time, and a couple of letters, by the way, asked why our board allowed that. I'd like to say publicly, our board didn't allow that. Something went on that we didn't know about. So I would like to, when we get to our note to the town council, point out there's more here than just the number of people in the house or the bedroom. And the other thing is the reason that we came up with 4 inhabitants or 4 persons in a structure is to avoid the bias of that word student. It's like it's a negative. And I was a student. We were all students, I guess, at one time. That just sticks in my craw. It's like, why? Even if there's, thank you, Mr. Berg, for your comments. Even if there's some extra effort in terms of the legal business of saying, 4 persons, 4 inhabitants, and it also carries through the year, through the 12 months of the year. So again, if people want to come up and make noise or whatever, I think that there should be rule on the books that first of all, you're in violation noise-wise, but secondly, you have too many people in the house here, and move on, so to speak. But as I said here, there are some very, very useful letters there in terms of how to raise money. We have 2,200 or so people who've registered, and I'm sure there are a lot of other people who didn't register. If they pay a fee, you can pay very well for a full-time inspector to make sure this all runs right. So those are my comments for now.
Thank you, Joe. And to Dr. O'Neill's point, Mike, that's exactly what I want to make sure that commentary gets to the council, because I think we're all going to have comments that are similar to that talk to the bigger issue than just what's in front of us as an ordinance.
Yeah, if I can just respond to the first part of the doctor's commentary. Well, I'm not the building inspector and I'm not absolutely well versed in standards of building inspections. I can tell you that any part of a home that is legally renovated for habitation, such as a garage or an attic or a basement, would be required to have 2 points of access egress. And one of those can be a window, but the window has to be of a certain size. So that would all be part of the building permit review process and the inspection process. Now, how many people do this work without a permit and add in bedrooms that are not legal? Those questions go unanswered, and we anticipate, we know that has happened in the past. But when they do pull a permit, we make certain, and I can speak to the building inspections office when saying, if they've pulled a permit, they are meeting the building and fire code standards. But it's still a very good point, Doctor, not trying to diminish it, because we know that oftentimes, well, not oftentimes, but there have been times when people have done this work on their own on a weekend with their friends with no permit and not met the standards that you'd speak of.
Okay, thank you, Mr. DeLuca.
Terry,
Anything else, Joe? Yeah, go ahead.
Not to beat on that, but you know what you're doing inside in your attic, nobody knows. If you seal those garage doors, nobody knows what's behind there. What's happening in your basement? Who can, you know? There's a lot of weekend projects by a lot of people, and you know, I just, when you're trying to be very soft on that, Michael. You know, people are in these multiple letters talking about these 6+ bedroom places. As I said, we've been here a long time, and most of these are in these 6,000 square foot lot developments. They're not in the 2-acre areas. So something's been going on quietly in the background, and you know, again, I don't think this is rare.
I fully
in any case,
comment.
Yeah.
Well, and yeah, and to the point of, and as Mr. Berg indicated, and others have indicated, current ordinance and this ordinance is going to be complaint driven. And I keep looking at this in relation to what Dr. O'Neill's just saying, and saying there's got to be a better way. There's got to be an inspection. In fact, if you look at the comp plan, Mr. DeLuca cited a section of the comp plan that talked about inspections. If these are rental properties, there should be an infrastructure set up where there's annual or biannual or some kind of inspection that's done by the building department, so that these illegally created multi-bedroom houses can't go on and on and on and create the tragedy that Dr. O'Neill is talking about is inevitably going to happen. So I think that whole aspect, and we'll talk about it more later, that whole aspect of inspection and certification on the building inspector's part, notwithstanding what the chief's doing in terms of aberrant behavior and what the police department has to do, but actual enforcement of the building inspector's office that isn't just complaint driven. So that's my point. Robin or Don or Vin?
I actually had notes on that exact situation or, you know, discussion point myself, is that, you know, it's yes, when you own a house, you have the right to do a lot of things to your own property. But once it becomes a rental unit that other people are living in, I think you are giving up some of those rights, because you are now turning it into a different situation. You are leasing it out to other people. And so I don't understand why there isn't some sort of inspection process. Whereas, I mean, I guess most recently it fell in line with what we do for liquor licenses. okay, so we grant these businesses their liquor license. If they have a problem during the year, because that liquor license is something that has to be renewed on a yearly basis, if there's a problem, they don't get that liquor license again the next year, or maybe not the same one. And I am confused as to why we can't do that for rental properties, because, you know, it's a business and it's no longer just your private property. You are using it as a business. You are having other people into your house. So there needs to be some sort of, I don't know, it makes sense to me to inspect the property to see how many legal bedrooms are there, how much available parking. We also have standards on parking. So if there are 8 bedrooms, but there's really only enough space for 6 parking spots, then you shouldn't have 8 bedrooms, you know? And I think it makes sense to make that registration of your rental and the permission to be a rental dependent on you, you know, falling in line with these legal obligations of mainly safety issues, you know? I mean, put aside the nuisance issues, put aside the noise. It's, you know, some of it boils down to just a safety issue of having too many people in a space that's not meant for humans. So anyway, that's just, I have lots more things to talk about, but I just wanted to make sure that Dr. O'Neill, I totally agree. And it's confusing to me as to why we can't make that right to rent dependent on a yearly inspection.
Thank you. Thank you. We'll come back to you. Is it Mr. Layton or Mr. Indalia to have any opening comments you want to make?
I'll make one, and it's on a completely different subject, but once again, it came up in the previous meeting from a person who she neither rented to students. I believe she was a resident, obviously, but she was more concerned about the message that the town would be sending. So this is on a completely different level. And I was interested in the correspondence, the letters that were following up. There was a lot of emotion attached to them. They either lived in a neighborhood where there were complaints, or they owned a rental property and it was going to obviously impact them financially. So you had those two sides of the stories, but then you also had a handful of letters that talked about the fact that the town is indeed a college town. It's attractive as a college town, and that the message that we would be sending could be quite detrimental. That's why I was interested in the chief's follow-up on the relationship with URI. But I was more interested in the letters that took the emotion out of it and just talked about the fact that this town is way better off with student population because of the vibrancy that it brings to the town. Obviously, there's an economic impact, and we heard about that. But my feeling right now is the message being sent in 2020, not 2021 or 2022, but the way this is written right now, that this would be instituted immediately, is of huge concern to me. So those are my comments that try to.
Excuse me, Don, you mean the effective date of passage upon, effective upon passage, that's a concern because of the timing in the school year?
That is correct. That's high on my list of concerns.
Okay. Joe, did you want, or Vin?
Well, I'd like to kind of circle it back just a little bit and go to the fact that as a planning board tonight and in these hearings, we sit more what I would call analogously to a subcommittee. You know, if you think of Congress, we sit as a subcommittee to both our executive and our body politic, which is the town council. Our ordinances and the state planning statute allows for the town council to create a statute, or I call it a statute, but an ordinance, which before they make passage, they want, at least in policy theory, the recommendation of a subcommittee that will seriously study all the issues and the impacts. And typically in these types of subcommittees that are created either for a corporate level or in Congress, the body that asks for that subcommittee's recommendation really takes to heart the work that that subcommittee has done. And on an issue that has generated so much consternation with landowners of different kinds, looking at it from different points of view, and the fact that it's pretty obvious that this board takes its job seriously. We're not elected, we're appointed for terms. We do what the mission of the council is asked, which is to study this. I would hope that the council really considers whatever we send back to them as a recommendation in light of what they've sent to us. Now, they sent us a proposed ordinance. Mr. Berg has made some suggested changes to that ordinance from his perspective as an attorney acting in the best interest of the town at the request of the council. So I think when we look at it, we need to look at it from several perspectives. One, what is the policy of the town on these issues? What is the, and how do we arrive at determining what that policy is? What do the people that have attended, which may only be a small fraction of the 14,000 or more residents, what was their voice and why were they here? Because many of them have a vested interest on one, two, or three viewpoints of what this ordinance arises in terms of issues, or brings to our attention in terms of issues. So I think that's really important, that when we do this, we not get too far askew and start trying to make policy decisions in a whole wide variety of other areas, such as, well, we should be enforcing our parking. Robin, no, you're right. We should be enforcing our parking. And Joe, how do we get to this? Well, I know where there's some 8-bedroom homes, and unfortunately, just because of where they sit, they weren't required to come before us for any type of peer review. They were allowed to build what they built as a matter of right. So, I think we really need to take a look at the ordinance. And when I think of what the policy is, the first two things I do is I think of the fact that when we are, as Joe said, we're talking about URI students, whether they're undergraduate students, graduate students, a mix of both. And we need to recognize that the University of Rhode Island is the crown jewel of our academic prowess for the state of Rhode Island. It's got graduate schools in a variety of different studies. It has more majors and concentrations of education than any other university. We have some fine universities, from Ivy League universities to specifically identified almost trade universities. Incidentally, by the way, when I say trade, keep in mind that if you went to the New England Trade School, you could have 50 of those students living, and they would not qualify under the definition of college students. So I think you need to keep in mind, and I think Chief Corrigan, Don's comments really emphasize that you need to look at URI as a whole. It's not just a building, it's its students, its staff, its alumni. And I get the opportunity, I know a number of us and a lot of these people in town who have testified and who are listening now have had the opportunity to go around the country. And we see it on Sunday during football season. You go to a place like State College in Pennsylvania, you go out to watch the Buckeyes. Terry, some of your favorite teams other than URI,
I don't have any other than you are. Go ahead.
Yeah, so, and you support your school, and we should, because we've seen over the years that we've had many students that have taken education here, learned here, had families here, and they've left the state for other opportunities. You know, I mean, I think we should be nurturing these people back. And we heard that from the testimony of a number of people. And in the last 3 weeks in the rounds of letters of many alumni, people who told great stories about how they met their spouses while they were at URI, how they went and they worked someplace else and they came back to Narragansett, bought their first home, then they rented it, and then they stayed here. I mean, I think we really ought to consider that. The second place of policy that I think we need to look to is the comprehensive plan. You know, I've been studying it over the last several weeks. 87 times we mention URI in our comprehensive plan. We have a whole section about housing in which it's mentioned 20 times as the University of Rhode Island and 15 times as URI, the acronym. We have whole discussions about how those students increase and decrease the population and the benefits of benefits to business that they bring. And we have a whole provision where we've given guidance and policy in the town comprehensive plan to law enforcement and enforcement agencies, which apparently Chief Corrigan has taken to heart, whether he knew he was doing it or not, by developing the relationship that has been espoused to be developed since at least 2012 and 2014, if not earlier, but really being pushed to be developed to have an open communique between the institution and the municipality. You know, those are kind of my opening statements. And I guess finally, I would say is that I do take seriously the Supreme Court's rulings that students are not a suspect class, and that certainly you can create a rationally based ordinance designed to protect the health, safety, and welfare of the public. But I think that the policy concerns of the city of Providence in a very centralized area, which was specifically around Providence College, that identified.
And Rick.
It is Rick, Terry, but you know, I know the people that brought the lawsuit. They had houses specifically in that Eaton Street area.
Oh yeah.
And that Eaton Street area has a number of homes that were single family homes or converted to single family over the years, and then purchased by people, and a lot of bedrooms were put in there. So it was a very condensed area where all of this occurred. And we have a different situation and we have different policies. They don't, if you look through the City of Providence comprehensive plan, which probably is not as updated as ours, Mike would know better, but they do not have a whole section on developing the relationships. More what they talk about with the universities is the lack of tax revenue that they're getting in their city. So, you know, I think that those are real important concerns that we need to consider when we develop this. And again, it's not out of disrespect for the Supreme Court identifying that you don't have to look at them as a suspect class, but I think we need to look at as property owners, neighbors to property owners, and really what it is that we're trying to do, or what I think that the policy behind this present ordinance is, which is to make it loud and clear that we're trying to control the behavior and conduct of those 18 to 24-year-old students who come to live in our town and be our neighbors. And I think we can, and I can give other reasons if you open it up later on as to why, and I'll put it out there now, this ordinance as drafted, as proposed, is not something that I'm prepared to recommend to the members of the council to pass and have our building inspectors and police officers and solicitors seek to enforce and prosecute.
Thank you, Mr. Daly. I'd like to go back to take a point Mr. Andalia raised and Dr. O'Neill and go back to 2016 when this board heard this issue prior. And I think the actual issue at the time, alluding to what Mr. Andalia is saying, the actual issue at this time was better defined. And I'd like to state what I think the issue is. And just so, because when we get done here, obviously the spin doctors will be out on both sides and people will represent things that weren't said. So I want to make sure that everything that people say is on the record, because the issue I see is controlling, eliminating, and doing everything we can to stop disruptive behavior in residential neighborhoods by, I'm going to say, seasonal renters. This is overcrowding, parking, abusive language, drunkenness, physical contact, general abusive behavior by people. And I don't think it's confined to students. And when we looked at this 4 years ago, it was unrelated people. It was seasonal rentals too. It was, and you can debate all day long. And believe me, some of the students are just awful. And Chief Corrigan can probably tell us all stories we wouldn't even imagine. And the ordinance has to control the whole strategy, the whole game plan has to try to control that. But when we go back 4 years ago, this board split 3-2 on the 4 unrelated. 3 of the members that were on that board are still on the board. There's 2 new members. I ultimately voted for that, but only because I thought it was important. 3 reasons. I thought it was important to set a bar. I thought it was important to set a number, because I'll go back to my naive view that people try to comply with the law. And I thought if the town set a number, that most people would try to comply. And I thought there was a value to putting a limit of the number of people in a household to try to control, as one aspect to try to control things. I thought the number was 4. I understand some people think it's 3. I think that falls under the heading that there's no right answer to that. I don't see any empirical evidence where the abuses drop off when you go from 4 to 3. I just think it's people's intuitive feeling as to whether it's 4 or 3. And I happen to think it's 4. But the last point, and the only reason I supported the 4 unrelated, was because I didn't want it only to apply to students. If we're going to be honest about this issue and try to control abusive and outrageous behavior by people who are there for a short term to have fun, who want to party, it applies, in my view, to all seasonal renters and should apply to all seasonal rentals. That's why I supported the 4 unrelated. I guess I read that Supreme Court decision 5 times. It's clear why I'm not a lawyer. I didn't follow everything about it, but I understand the rationale that they're not a suspect class. I get it. I still don't think it's fair to put it on the students solely. I think the 4 unrelated, it encompasses the students. You can debate the 4 and 3 all day long, but the 4 unrelated is going to apply to students as well. I don't see narrowing it down. I understand there's some rationale that, well, that's because the Supreme Court decision is going to be easier for us to enforce and it's going to be less challengeable. But then we have our solicitor saying he feels the 4 unrelated has the shackles have been removed by the Supreme Court decision. So again, I think the issue is controlling disruptive behavior in residential neighborhoods. People that live in those neighborhoods have to have this under control. And the chief and his team of officers is doing everything they can, but there's other things that need to be done. And it doesn't just apply to students. And I know we can debate, everybody's got a different reference point. I'm not belittling or minimizing the people who live in Eastwood Look or Bonnet or San Hill Cove who have had horrific experiences with students. I know that. But other people have had not so nice experiences with summer renters. So I just think seasonal renters, and if you look at the Supreme Court decision, they make distinctions about students. They don't talk about seasonal rentals, but they make certain characteristics of students that I think applies to our seasonal renters. They're here for a short time. They don't have a vested interest in the community. They're here for fun. That's basically what the court said about the student population in Providence. And I think it applies to the seasonal renters too. So historically, that's why I supported the 4 unrelated. But again, the issue is getting at the disruptive and abusive behavior in our residential neighborhoods, which has to be stopped. So again, we're going to make a motion specific to this ordinance, but I think this discussion and some of the other points that are going to be made before we end have to go to the council. Because as Mr. Indalia says, Dr. O'Neill said, and others, there's other things that come into play here besides 3 or 4, student or non-student. So anyone else? Joe?
Well, yeah, you want to beat a dead horse here, but we walked this road back in 16, and there was a lot of conversation about the 3, 4, and 5 bedrooms. And I remember the various single-family homeowners groups finally went along with the 4. They wanted 3. I think some of those groups who are today who are so outspoken about the number 3 went along with the number 4, and we decided it was a reasonable number. I think we're hearing from legal counsel that it's defendable. It's on the books. It has not been. I don't feel it has not been enforced. I think Terry's point is a good one. Most people are honest. If that law's on the books, we got some letters from those people, right, where they created homes that had 4 bedrooms with that in mind, so that they could rent 4 bedrooms. And so, what's interesting here is that if the town council in its wisdom goes to that number 3, these people are now in violation, and their neighbor or whoever can drop the dime, so to speak, on them. So I just think we walked this road in 2016. We have a law in the books that is so reasonable, and it's a matter of enforcement. And the enforcement issue has to be worked on. Now, obviously, we don't have the power. We have the power to recommend, I guess, as a planning board, but we don't have the power to create a way to enforce, which the town council has. And in my humble opinion, the people who are pushing for the number 3, pushing the town council in this direction, that would go away if there were no complaints, if the complaints had disappeared. So I think there are ways to attack that without creating this 3 and also I can't say it too many times, creating this sort of a negative connotation about the word student. Most students are not creating this problem. Some are. But as Terry pointed out, there are other people renting who are not students who create this problem. And I don't know if Vin mentioned earlier, does the word apply to other people in other professions and other schooling? Then they wouldn't be considered students, but they could still rent here. So, in any case, why I just there's no way I can encourage the town council to support this number 3 kind of law that they're considering. I just for all those reasons.
Thank you, Joe. Anybody else? I have a couple other things, but Don or Robin or Vin?
I guess I just want to say that I agree, because I also have a problem with just identifying it as students. It just seems, I don't know, it seems silly because I mean, I think that summer people can be as disruptive and as disrespectful. And it's not just students. And also, importantly, there are tons of students that we heard from and landlords who are housing these students who are doing the exact right thing. They're following the rules, you know, they're having, they're getting involved in the community, they're, you know, inviting their families here, they're buying houses here. So I don't feel comfortable just pinning it on students at all. I think it's.
What do you think about the 4 of the 3?
I'm much more comfortable with 4. I'm not comfortable with 3 at all. I feel like it's too, I agree with you. I think the number is sort of arbitrary. And I don't like 4 either, but I like 3 even less. And I mean, you know, you guys know me. I talk about families all the time and how this town needs to consider its families and, you know, take care of its family residents. I want to make sure that the families are taken care of, but that doesn't mean I don't want students here. It doesn't mean that I want everyone to be, you know, a small family with kids filling up the school. I like having the students here. I like having the retirees here. And, you know, some of the seasonal stuff, it is fun. It does add to the interest of the town. And it's, you know, it brings people here that we wouldn't have as a part of our community otherwise. And I think the students are valuable, and I think the families are valuable. So.
And the summer people. I mean, they're not
Absolutely.
all.
Absolutely. They're
Obviously.
all important. Yep.
Thank you.
Even if they come from Jersey.
Yeah, right. Right.
Even people from Jersey. Just kidding.
So, to Mr. Indalia's point, and I just want, and again, to this point, Mr. DeLuca, where we send, Mr. Indalia, I think properly said that, you know, the town council, while our motion, again, I've said many times, has to be specific to what was sent to us, we're still making commentary to the council as a subcommittee, as an advisory group to the council as they deliberate this. And I just think, I've already spoken on my view of the unrelated versus the students, and I agree with others here that, especially if this is an ordinance that we can now put into effect, that we need to do the 4 unrelated. I also think, and as great a job as the chief and his force has done on the enforcement of you know, illegal behavior, for whatever the term is, or awful behavior, even sometimes lawful, but they do a great job in that regard. I think the town council needs to commit resources, however they fund that, to the enforcement arm of the building inspector's office. An ordinance that can only be implemented or instituted or put into action by a snitch line, to borrow the NBA phone call thing that they have to turn in people that are not COVID compliant. To have a snitch line as the way to do this, for people to drop a dime, is not a good way to enforce it. And it speaks to the safety issues that Dr. O'Neill, we have to have, and the comp plan mentions certification, registration, inspection on a regular basis to help ensure that these things don't occur. So the enforcement arm, the number of people in a house is one component. The enforcement arm has 2 components, the police and the building inspection office. And my last point, to many people out there who aren't aware of it, there are some, because they alluded to it in their comments last week or the last meeting, some members of the public are aware of it. This board, with a 4-to-1 majority, sent a bulk zoning ordinance to the council that is going to, if it works, eliminate, reduce, significantly lessen these dormitory type structures that are being built. Now, the number of people in a house has to be able to be there, I think, to address the existing houses. And to Vin's point, that some of these are 6, 7, 8 bedroom houses that were there by right. But there's a new standard if this bulk zoning ordinance gets put in. And any new construction is going to have it's going to be a very difficult thing to build those houses going forward. So it's not going to take care of the existing ones, that aspect, but it's going to take care, or it's going to significantly address the future one. And if people say, well, Terry, there's not many open lots in the R10 and R20 zones. That's not the point. That's a false argument. This board, this town, these departments, this board, the zoning board, the inspector, the building inspector's office sees every day tear downs and rebuilds. Tear downs and rebuilds. We see it every day, guys. Small capes, small ranch houses get knocked down, and now these larger buildings are proposed. We're going to be facing that forever if the council doesn't put in a bulk zoning ordinance. And it has nothing to do with the specific recommendation we have in front of us, but it does have everything to do with the bigger strategy that the council needs to consider. So I would, as part of our commentary, Mike, if you can pass on, at least from me, and if the other board members agree, the council do everything they can to take a look at that bulk zoning ordinance, get it out from whatever legal constraints are hovering over it now, and deal with it, because it's going to do a lot to reduce the future construction of these 8-bedroom dormitory style houses. And one last point, and I think Dr. O'Neill alluded to it with respect to the 4. People talk about investing in their 5, 6, 7, 8-bedroom houses. I get it. But in all fairness, folks, you bought that in the last 4 years and you did your due diligence, you saw an ordinance on the books that said 4 unrelated. So if you're going to invest in a 5, 6, 7, 8 bedroom, you got to know that might come out of the unconstitutionality realm at some point, which it appears it has, and that you're going to be held to that 4. So you did that if you did your homework with a certain expectation that it may not last for a long time. The people who did their homework and bought the 4, and there was actually one person that alluded they were looking at a 5 and a 4, and they bought the 4 specifically for this reason, because they looked at the ordinance. If that now goes to 3, I think that's a severe, unexpected, and maybe unfair occurrence for these people who did buy a 4-bedroom home. At the end of the day, I don't know that we have an obligation to any of that, but I think from a fairness perspective, that's my view on that. So again, I just want the comments, if you could, Mike, about this multi-pronged attack that includes some unrelated or student component, but it includes these other things as well.
Understood.
Thank you. Who's next?
Um,
Ben?
I don't know, Don, we're staying in the same order. You want to go?
Just one last comment about, I think, again, the schedule, the timing of everything. There were several letters that certainly mentioned the fact that rents have already been signed, agreements signed. To do something at this point, I think would be so disruptive and so counter to what you, Vin, were saying, that we really need to be the college town that welcomes URI, not shuns them. And I just think this is the bad timing with everything that's going on right now. So I just want to make that part of it too, in terms of the unfairness, that there's legal documents that have been signed that would be just an absolute nightmare to sort out if this were to go forward.
Don, if I could just jump in on that. This is a zoning ordinance, so even if it was passed, if the leases have been signed and or the occupancy has taken place, there would be a very, very strong argument that those structures become a pre-existing non-conforming use, and therefore, at least for this rental term, would therefore not, the new ordinance would not be enforceable against them as in any other zoning ordinance. So while your point is well taken, it might not be a battle that the town wants to fight should any ordinance take effect immediately upon passage, although certainly your suggestion is well taken as far as delaying the effect of the ordinance. But I think even if the ordinance did go into effect right away, there would certainly be a potentially valid defense on a pre-existing non-conforming use, at least for this one term, this one rental term.
Well, Steve, let me ask you a question.
I would agree with what Steve is saying as far as enforcement goes. I think whether it's when the ordinance goes in effect or whether it's in effect and we just don't choose to enforce it against pre-existing leases, I think that that's something that would be taken into account.
So Steve, are you saying that I should, if you're watching this today and you have a couple of rentals out there, you should go out and amend your leases and give everybody 20-year assignable, renewable options from year to year. And well, I'm grandfathered in because the guys next year can renew the option and it was pre-existing use. And the guys and then they can assign it afterwards. I find that kind of hard to believe. What you're saying is essentially,
well, again, I only
town won't exercise it ex post facto, when in fact, if you say that it goes into effect, there's a gazillion statutes out there where contracts become null and void tomorrow. I respect your advice all the time, but
again, but
why invite our residents to pursue litigation with our town?
Well, I can tell you this, Vin, the lawyers are lining up already. So
yeah, no, I understand that.
You can't pass or not pass an ordinance based upon that. So.
Steve, but would your preference be to, if they pass it for a future effective date rather than
at this point, I defer to Andy, but I think effective upon passage at least gives the owners, you're giving them essentially a year long, you're giving them a certain period of time notice for the next term lease.
Yeah.
I would agree with Steve on that. I think the ordinance should be effective immediately. That's just a matter of deferring on enforcement to give people some notice and avoid arguments about interfering with contracts or pre-existing uses or anything of that nature.
And let me ask you, are you both Andy and Steve, are you confident that the way that this ordinance is worded, that it does not provide a private right of action? It is only a right of action to the town?
I mean, I'll defer to Steve. He knows zoning better, but from my understanding, zoning is a function of the town enforcement.
Yeah, correct. I agree with it. And the enforcement would only be by the town as a normal town, either the town building official on an ordinance violation. Obviously, the only private right of action would be what someone has now, which would be a nuisance action or something like that.
Right, but so in other words, somebody couldn't say, well, I live next door, there are 4 college students there, the building inspector hasn't done anything, I'm gonna bring a lawsuit under the statute for damages, a remedy, injunctive relief, et cetera.
No, not in my opinion, it does not.
Fair enough, thank you. Terry, but I did have some comments.
Go ahead, Vin.
If Don was all done.
Fine, thank you. And that conversation was good to hear, and I'm sure those listening will appreciate it as well.
Thank you, Don. Go ahead, Vin.
So Terry, I go back where you said in your idealistic world that most people try to comply, which is why you passed a vote.
Yeah, I'm sticking to that, Vin.
Yeah, and you should, because I think it's the right way.
I think Vin got hung up.
Can you hear me now?
Yeah.
Yes. Yep.
So I was one of the 2, by the way, in the last vote. And what I'm going to tell you is again, I look at what the policy is that's trying to be accomplished by passing this new law. While the Supreme Court may have ruled on certain constitutional issues, other issues were not raised to it. On page 201, we have a direct action plan comment in our comprehensive plan. which is to encourage URI research parks and development and invite URI into our town. We do have discussion, on the other hand, at page 97 of the comprehensive plan about tear downs and build ups, which you were just referencing, Terry, which is that comprehensive plan policy goes directly to a law this board recommended to the council, which would help alleviate the massing and bulking up of condensed residences without violating other policies which the town council itself passed as being positive. Yeah, and I want to address in that regard, some of the following things. We got a letter from the town of Narragansett, a lobby group entitled the Peer Residents Association. And they pointed out that they complied with rules that we set for this hearing. And I want to let those 100 or so members recognize that it is abundantly clear in their very well-written letter of July 9th that they have a cogent, well-organized rationale for why they support a 3-person limitation if you are a student in town. While some of the facts I think are speculative and not supported, such as allowing more than 3 students causes a significant increase in our budgets to the police department. Nevertheless, they point out that bad behavior by bad students or bad behavior by people that can't conform to normal societal rules is a burden on our resources as a town. That can't be denied, but we have that in any event. I want to point out that it was not lost on me, the family, and I'm not going to mention names because they just don't need to be thrown out in the limelight, but that lives on Willow Ave in Sand Hill Cove, who experienced, at least on one occasion, a very bad night or a bad day and had reasons to be concerned. And if they're listening, those concerns aren't lost. And it shouldn't fall upon them to be the police sergeant of the neighborhood. But simply limiting 3 people to living in that house at the end of the dale there wouldn't have prevented students from having a large party, inviting a lot of people, hundreds of people, it looked like, to their home. It would, however, have prevented some of the parking issues, I'm sure, a lot of the time. And I'm assuming that they weren't just gilding the lily by sending a picture of 10 cars parked in front of a house. I'm assuming that that was what it was like on a regular basis that particular year. So those concerns aren't without, but I also drive through the town 2 to 3 times a month, not just driving through the town, but when we get our packets from Heidi and when Mike advises us of what's going to be on the following agenda, I drive through these neighborhoods. I've grown up in this town. I've been here since I was 8 years old. I've rented in this.
So you're not a local.
I am not. I am not. I am a carpetbagger, Joe, just like you.
Yeah.
I think I came in 2 years after you got here. So, and you weren't 8, buddy. But,
No.
So, we've seen the development of the town and we've seen the URI. I can remember I was in college back when URI was an All-American football team. And, there was some rowdy action then, but it seemed that the police were able to address it, adapt to it. Sand Hill, Eastward Look back then was a brand new development, I can tell you, from 1978 or so, Joe, right? 77.
Yes.
Started building up. And most of the people that lived in there were full-time residents. They've sold their houses and moved on. And the culture and the environment has changed, and I'm sure it will change again. We're starting to see that change now as more and more people want to leave urban areas because of the current COVID crisis and are buying houses here as full-time residents. Robin may get her wish that there's a lot more families coming back as opposed to leaving. And we may see that the Narragansett schools are filled again, beyond 400 students at the high school, or 300, what it might be this year. So in essence, to the town council members, my recommendation is that the current ordinance presented to us for review and recommendation does not meet the goals and policies of this entire town. It doesn't meet the goals and policies of a lot of residents. And there are still some residents who would approve this ordinance. And they have very cited individual reasons for wanting that. And I hate to use terms like the tail wags the dog, but it seems to be things that people understand. And it can't just be the vocal few that make the people that are making decisions because they were voted into office erroneously make a decision because, 4 legs good, 2 legs bad type mentality. So, I really think that this recommendation ought to be very specific, that this ordinance does not meet the goals and policies of the town comprehensive plan, that it does not foster a relationship with the University of Rhode Island, which this town has been trying to do for many years. It does not foster state goals and objectives, which are to continue to educate people from within and without the state, using this as our crown jewel of academia, and incorporating these young minds into our town. And finally, that the ordinance as drafted, to the extent that there is a desire to modify the behavior and conduct of students, that limiting them to 3 people per house will not stop them from having a party. There's no evidence of that. There is no evidence that they will abide by the rules. And there is no evidence that their breaking of the rules of having girlfriends, boyfriends, friends, all move in with them or spend the night or occupy the home, however that may be defined, since they are not the target of the punishment by Mr. Berg's own words. They will not be punished for it. They will not be fined for it, but rather the person who rented their home in good faith that the lease might be abided by is going to suffer some kind of consequence. I just don't see how limiting those number of people accomplishes changing the behavior of a handful, because if you look at their comprehensive plan, which spent a lot of time analyzing the numbers, it goes from 1,400 to 1,800 students moving into this town of Narragansett for a 9 to 10 month period. There is no way that you are going to tell me that 1,800 students are unruly and misbehaved in this town. Chief Corrigan would put in his retirement tomorrow if that were the case. So the goal of changing that behavior needs to be accomplished in another way. Our recommendation should be that this ordinance doesn't do it and that this ordinance shouldn't be passed. And I'm willing to discuss that with anybody that has questions about it.
Vin, would you go further to encourage the council to move towards enforcement of the ordinance that's already on the book? Or did you not want to talk about the 4 unrelated at all?
Well, I will talk about it since you brought it up. In our recommendation, I just try to kind of stay narrow to what they give us
Yeah.
to do.
I get it.
You know, we all have opinions as to what somebody could have, should have, might have done if they were on the town council. And my answer to that is, well, if you want something done on the town council a certain way, you either lobby for it or run for office. But you know, yeah, the ordinance of 4, our solicitor, our prosecuting solicitor, who's Andy Berg, who, you know, is a great prosecutor and really does understand the law. He believes that ordinance is completely enforceable. And I think it does. Look, I was against the ordinance.
Right.
I didn't think that we should be doing that. I thought that the current, I think that there are still other laws in place that take care of that. I thought that saying that people, 4 unrelated persons in one household, I think that's what it says,
Right.
shouldn't be allowed. And you know, that's just, I think it's an enforcement problem in and of its own,
Well,
because
excuse me, let me interrupt you. My recollection of your opposition might have been on many levels, but a big part of it was that you thought it was impossible or difficult, if not impossible, to enforce.
I do.
So it had no merit in that regard because you really couldn't put it into effect. True?
Couldn't put what into effect, Terry?
You couldn't enforce it, so it really had no meaning.
Yeah, I mean, you know, you rent out a house for a week, or you rent out right now, right? COVID's here. People are trying to rent houses for two weeks at a time, a month at a time. And, you know, you don't know if they have 8 people, 6 of whom are unrelated. And, you know, what are you gonna do? Knock on their door and, you know, show your swastika and say, open up and let us in? It's just not gonna
But let me just again interrupt. I just wanted to ask you a question, but you're not as naive as I am to think that most people, if that 4 is in paper, if that's the law, they're going to try to comply, which is again, the reason I supported it.
I do believe that those landlords who register with the town as having rentals, I believe that those landlords who have summer rentals and comply with the state law to register with the Rhode Island Division of Taxation and pay their 7% sales tax as a luxury tax for renting their home, absolutely will attempt to comply. I think our larger landlords, you know, again, I'm not going to mention names, but who have sat on the council perhaps, all try to comply with those laws as they're done. I think there's some people out of ignorance that don't. And then I think there are some people that are just ignorant that don't. But that's like anything else.
Well said.
So I think that is a tool, Terry, coupled with our nuisance ordinance, our sound ordinance,
Right.
our various misdemeanor ordinances.
And hopefully our bulk zoning ordinance.
Well, and true, if the council looks at the bulk zoning ordinance, which is specifically set forth in the policy considerations of their comprehensive plan that they passed at page 97, which talks about tear downs and rebuilds and bulk ups, that statute or that ordinance falls directly within that policy to ensure that the bulk ups don't result in interior overcrowding of bedrooms, et cetera. So for all of those reasons, I simply can't enforce it. And I don't think it should be lost on people that, you know, we should be supporting our state university and those kids, even if they can be jackasses from time to time. And, you know, I've lived next door to them. I live on Lake Road in Bonnet Shores. I've had those parties and those events. You know, maybe I'm just a little younger. Maybe I'm a little more tolerant. Maybe I'm a little more.
Maybe your
forceful.
hearing is bad.
I'm sure after this lecture that I've just given everybody, they wish their hearing was bad too. So, you know, on that, Joe, I appreciate it. I'm going to end it. But, those are my points, and that's why I'm getting that vote that way.
Thank
You want me to
Mr.
second the
DeLuca.
motion? No.
Well, I don't know if we're
Yeah.
at a motion
Yeah.
yet, but,
No, I'm just, hey, Terry, you're very serious here tonight. Can I bring up something else?
sure, go
Sorry.
ahead. Yep,
Yeah, I think the reason for us having this conversation and the hundreds of people who are interested in this topic is enforcement. The number of 3, 4, 5 isn't the issue. It's enforcement, and the police can only come when all hell breaks loose. We have not created, we never did, enforcement situation way to prevent a lot of these problems from happening, and when they happen, for the people to be disciplined, whether it's the owner or the students or both. And I think if that doesn't happen, we'll be talking about this again in the future. We were talking about this 4 years ago. We'll be talking about 4 years from now. So the whole idea of this law that just Providence passed, and that the town council, I'm sure they're pressured by a lot of homeowners, feel this is a great idea. It's not a great idea. It's not going to be enforced in any different. All it does is, it's very offensive to a large segment of population. Students, I guess, stand right out. So I just think that unless there's a mechanism, and the town council has to accept that, of creating enforcement to pass this 3 students in a house, it makes no sense other than it just rattles the cage. It doesn't solve a social problem here. So in any case, I just want to
Thank you,
make sure I made that point.
thank you, Joe. Don or Robin?
Go ahead, Don.
I'm fine. I've heard a lot of good statements tonight, and I agree with them all. It comes down to enforcement and actually enforcing what's already on the books. Maybe that's the part that the council really has to look at.
Thank you. Robin?
Yeah, I mean, I guess just to not let the point pass by, because I agree. I don't think 3 is where I want to go. I agree with Vin. It doesn't fall in line with our comprehensive plan. I do want to say that I want anyone who owns a property and rents in this town to be responsible and respectful of the people who live in this town. And whether that's retirees or families or whoever, and hopefully the enforcement issue will take care of that. But, if this means that some of the properties get sold to families and we have more families in town, I won't be devastated. I understand that this is what a lot of people do. They own a house here and they come enjoy it in the summer. And that's really nice to have. It's a nice tradition. It's great. But I want to make sure that those people know that we're not looking for this town to be quiet. We're not looking for it to be, just all people who are all the same. And I think that sometimes when I read the letter and it said, we hope to retire there someday, I'm thinking to myself, okay, well, that doesn't get any more families in town. And it also, some of the letters that talked about, students support the local economy. Well, so do residents and so do retirees. So I feel like we really need to make sure that, our town does stay diverse, and that we're not saying we want it to be so quiet. We want it to just be, the sleepy little beach town. We want it to be all retirees. We want it to be all students. we want it to be, part of the beauty of Narragansett is that we have all this, these people who come and live here for part of the time. And I don't want to lose that. But if we do lose some of them because landlords say, well, forget it, this doesn't work for me because I have an 8-bedroom house and I want to keep renting it out to 8 people, then, there's an issue of respect there. And maybe having something with enforcement with reasonable numbers will bring a type of student that's, more a part of the town, and a visitor that's more a part of the town. And I think the way it's been presented to us is not the way I see it being successful and moving forward. But I do think that it's an important discussion. Lots of things have been brought up. We have things to work on and progress to be made. So.
Thank you. Yeah, I'm going to go back again to my premises, and I don't think anybody disagrees with me. Maybe they do, but I certainly understand that there's abusive and disruptive behavior in neighborhood communities, residential communities that need to be addressed. And I think it's addressed by those 4 components that we talked about: enforcement of the police, enforcement of the building inspector's office, some limitation on the number of people in the house, and the bulk zoning to limit those dormitory style houses to be built in the future. I think if the council takes all that, and particularly with the advice from council that the 4 unrelated is ready to go, and that puts a limit on the number of people in houses, and it includes students for the most part, unless there's a couple students that are related. The 4 unrelated will take care of the limitation on students. I'm not sure why we need to go to 3 students and specific to students as opposed to all seasonal renters, which I still think is the issue. Noise, abuse, behavior, drunkenness, overcrowding, parking, loud parties, large parties, all that is an issue that needs to be taken care of, but I don't think this ordinance advances to that. So I agree with you guys on that. I don't know where we go now. Again, Vin, I think you articulated the view on the motion. I thought we might have a separate motion for the consistency with the comp plans and the principles of zoning, but maybe that's, if you want to form a motion, it encompasses everything into one, which is fine. It's up to you.
And do we need a separate motion for the college student definition? Or can we encompass everything into one?
I think if we were going to make a recommendation, if the motion was to approve with modifications, that may be one of the modifications. Correct me if I'm wrong, guys. But if the motion is to reject what the council has sent, I don't know that we need to get into that, but I'll open it up for anybody's opinion on that.
Can I make a couple comments?
On that issue?
Procedural comments. I don't want to talk about the content. I think you guys are doing a great job dissecting and deliberating on this. This is a real sticky issue, and it's one with a lot of many facets to it, as you've seen through the comments that you've received. But if you were to, I just want to remind you of the typical process we go through, and I think we should try to stay close to the typical process. There's usually 3 options for you whenever you're making a recommendation to the town council: approval as drafted, approval with stipulations that might read as conditions for change, or specific regulatory provisions that you encourage to be added, or denial. And if you do recommend denial, then remember to articulate the reasons why. And when you articulate the reasons why, that you may suggest that there could be improvements made if the foundation of the ordinance has some merit to it, or that the, in the alternative, in this particular case, the four unrelated ordinance is satisfactory on its own. Now, I'm not putting words in anyone's mouth. I'm just saying, remember those are your options. Approval because you love it. The way it was written was perfect. No changes needed. Approval with some conditions, or denial with reasoning. And just as you did with the RV storage ordinance, you had suggested denial, not because there was a bad intent, but that there wasn't enough in that ordinance for you to feel, as a group, to feel comfortable supporting it. And you asked the town council to return it to you, which they did, and staff is working on. So I just wanted to get that procedural commentary in for everyone to kind of frame their thoughts.
Well, also, there has to be a reference to principles of zoning and the comprehensive plan.
Well, that's in my memorandum. And again, I would suggest that you might work off of my memorandum as a base, but you don't necessarily have to use all of it. You can use
No, but would that all be wrapped up into one motion, Michael, or do we make multiple motions?
It can go either way.
Right.
It depends on how far you want to dissect it and how detailed you want to be in the commentary you give to the council.
I'll leave that to the motioner. Obviously, all the commentary that the boards have will go on to the council in form of the summary, but we do have to structure a motion that's specific to what's been presented to us. So
Right.
someone want to take a shot at that?
I'm hoping Vin does.
Yes, my new name's someone.
Oh, this is the benefit of the chair. I can't make a motion. So I just said, does someone want to make a motion? And I'll see. Robin, Don, you want to take it over for Vin, or Vin? It's up to you, Vin.
I'll take a stab and then anybody can amend it as they, obviously, as they see fit. So let's see. I'll make a motion that we make a recommendation to the town council to not pass the proposed ordinance as sent to the planning board for review and recommendation, and as amended, and I'm not quite sure with the council's consent, but as indicated by Solicitor Berg with regard to the definitions that he suggested be changed and recommended back to the council if it were to be passed. But I recommend that we suggest that they not adopt or pass any version or amendment of that proposed ordinance. I would further make as part of the motion that the ordinance does not conform with our town's comprehensive plan, the action goals of the plan, or the policies and spirit of the comprehensive plan, which is in fact to, one, encourage further and continued involvement between law enforcement and the public community services that are supported on the town budget, to coordinate with the University of Rhode Island through its Dean of Students and its student body directly with regard to their seasonal and full-time housing in the town of Narragansett. That the current policies that have been adopted with prior town councils and maybe even some of the members of this town council with regard to open containers, noise ordinances, et cetera, are sufficient and cited in our comprehensive plan. That it does not conform with our town comprehensive plan in that we have a specific action goal to encourage further development of URI with research parks and students in the town. And that it doesn't conform with our state comprehensive policies to encourage, expand, and promote our crown jewel of education, which is always filled with students, regardless of their age, but the majority of which are ages 18 to 24. So that would be my motion. And Mike, I know you had other things in your memo, but
Vin, excuse me, just to interrupt. You alluded in your previous conversation of in the comp plan, it referred to the provision that actually talks about the bulk zoning. Did you want to work that in there at all?
Sure. As a further part of the motion to recommend non-passage of the proposed ordinance, that we direct the council to consider, based upon our study of the town comprehensive plan, which was put together by this board and approved and ratified by the town council, with regard to the section entitled Tear Down, Bulk Up, found at page 97, which discusses overseeing and considering that many homes in town, since there's a lack of land, will be torn down and rebuilt, that in that bulk up, the town pays specific attention to ensuring that those houses do not become overly dense or created such that, you know, they become rooming houses, and that we provided to the town council a proposed ordinance in compliance with the goals and policies of the comprehensive plan that could be yet another tool to prevent overcrowding and overconstruction of homes, which would directly affect those people who are apparently proponents of the 3 student minimum. And it seems that they're proponents of it because of their concerns that there are so many people bulked up into a house that it is simply a impetus for unruly behavior. So that this ordinance would just be another tool, and it would be a long-term tool because it would prevent that bulk up forever from occurring. So that would be part of my recommendation motion that I would ask you folks to approve and passing it on to the town council.
And to your question to Mr. DeLuca, Mike, is there anything that procedurally we should consider, or Mr. Indalia would consider as an amendment?
Well, no, I, you know, he's gotten right to the point of, you know, the foundation of his objection to the ordinance as drafted. As I went through the 4 standards of review for consistency with the comprehensive plan, I will say that I left the window open for you to draw a conclusion in either direction, because my complete conclusion at the end was that the comprehensive plan, that this ordinance as drafted does not address directly an action item or a goal or a policy of the comprehensive plan. Conceptually, it could, but there are arguments on either side of that. So you may or may want to remove some elements of what I've said in the plan in the report, but what I've said at the end of that consistency text related to comp plan and related to the zoning ordinances, there really isn't enough, is not enough.
Well, I don't think we're going to remove anything from your report. It's just what, you know, it's Vin's motion, so we're going to act on that.
Right. Yeah. So what I would say to that as discussion to my motion is that you're right. I would not ask that Mike remove anything from his report. His report is his report, and it was well done. I would disagree as to whether or not there are action plans, and I think I've found those areas, and you could also refer, as I pointed out earlier, to the other 20 sections where it refers to URI as an acronym, the 15 sections where it refers to URI students, And then the 87 other points where University of Rhode Island is mentioned, although not always with regard to students but talking about the great impact that it has on this town and the state. So I do find, and that's why my motion is worded as such, that there are specific, and I think I've identified them specifically, page 201, section 4, and page 97 that support my motion.
If I may then, if the motion does pass, I will make an appropriate adjustment to the staff report because it will be sent out under your signature, Mr. Chairman, to incorporate the commentary of Mr. Indalia, particularly as it relates to all of those positive references to University of Rhode Island, which I did not put into the staff report. So I would enhance that report to incorporate those comments.
Okay, thank you. Does anyone have anything to add?
I'll second Ben's motion.
So Mr. Indalia has made a motion and it's been seconded by Dr. O'Neill. Anybody on the planning board, on the legal staff or staff have any comments before we vote? Nope. Okay, silence is consent. I'm gonna call it Mr. Layton,
Aye.
Ms. Blasiak,
Aye.
Mr. Indalia,
Aye.
Dr. O'Neill,
Aye.
Mr. Fleming, I'm an aye as well. Just so that the public knows again, August 17th, I believe the council has on its agenda to hear this. And they will have a full public hearing, I believe, with sworn testimony and the like, and the stenographer. And then that's the next step, from what I understand.
Mr. Fleming, they still run their meetings on a Zoom format, right?
I don't think we're back in town hall yet, even though we are for day-to-day business. I don't think we are for meetings yet.
Okay, thank you.
I think we might be looking at September, but no way of knowing. Certainly not August.
So the August 17th council meeting is more than likely on Zoom, but it'll be advertised.
Yeah, and the governor just shrunk people down to 15 again, so I wouldn't, it's not going to happen.
No kidding.
Yeah, so
September's probably not even a possibility.
yeah, I would say the end of the year, guys, because
Yeah.
they're not going to allow, gatherings of more than 25 or 50. So you really, it's impossible to schedule a meeting because then if 53 people show, it's going to be a logistical problem. So.
Yeah.
Yeah,
No way.
I'm all in favor of this process. That's been working for me.
Thank you, Mr. Marcel. All right, do I have a motion to adjourn?
Motion to adjourn,
Dr. O'Neill, do I have a second?
Dr. Neal.
Second.
Second, Ms. Blasiak. I'll take a roll call vote. Mr. Layton,
Aye.
Ms. Blasiak,
Aye.
Mr. Indalia,
Aye.
Dr. O'Neill,
Aye.
Mr. Fleming. Aye. Thank you all for your time and thanks to the public as well. See you later, guys.
God bless America.
Take care. Thank you.